Good morning, everyone, and welcome to today's employment law webinar. Thank you all for coming and tuning in this morning. My name is Marty Rabinovitch, and I'm a partner at Devry Smith Frank, and I head up the employment law group. And I will be joined today by Stacy Glass and Kathryn Benson, who are human resources consultants at HR Options. And I'm sure Kathryn and Stacy will introduce themselves and tell you a little bit more about what they do. So again, welcome. So for human resources professionals in attendance for today, the program has been approved for 1.25 CPD hours. We'll get you the code that you need to report those hours after the seminar. And then for any lawyers who are in attendance today, the program does count for 1 hour and 15 minutes of substantive CPD hours through the Law Society of Ontario, so don't forget to claim your hours. Here is today's agenda. So in just a couple of minutes, I'm going to turn things over to Stacy, who will start things off with a presentation about navigating employee leaves of absence. And then following Stacy's presentation, Kathryn will take over and we'll give you the HR perspective on conducting employee terminations. We will then take a break from 10:45 until 11 o'clock. And then we will resume with my presentation, which will be a 2023 case law update. So it's only April, but yet there is already a lot of new developments happening in employment law. So you'll hear a little bit about that at 11 o'clock. And from there, we will have a Q&A period, and then we'll wrap things up at 11:30. Now, just a little bit more about the questions and answers. So feel free to submit your questions as you have them through the question and answer feature on Zoom webinar. We will do our best to answer as many questions as possible. We will answer some of them throughout the webinar by typing answers through Zoom. And then if we have any additional questions, we will answer as many as possible in the live Q&A period starting at 11:20. If we don't have time for your question, feel free to contact any of the presenters afterwards, and we will answer the questions. And then I do want to say as well that one of the most frequently asked questions that we do get is whether or not the slides will be available. And the answer is absolutely yes, they will be available. They will be posted on our firm's website shortly after the seminar. And you can also contact any of the presenters and we'll get you a complete slide deck as soon as possible. I did also just want to say that this is the first seminar that our firm is hosting in 2023, and we typically host these every quarter, so once every 3 months or so. Anyway, once again, welcome, and I'm now going to turn things over to Stacy. So, Stacy, it's all you.
Okay. Oop. I'm just going to share my screen. Okay. Okay, thanks. As Marty mentioned, I'm Stacy Glass. I'm Associate Director with HR Options, and it's my pleasure to be presenting today along with my colleague, Kathryn Benson, who's the Director at HR Options Canada. And Kathryn and I have both been with HR Options each for over 19 years, and we work with a wide array of companies, ensuring that our clients are compliant with employment legislation, HR policies across Canada, as well as payrolling, recruiting, training, and HR policy development. And at HR Options, we provide consulting and payrolling services throughout Canada and the US, and we have been doing that now for over 30 years. And on that note, we will get started with today's presentation. Okay, so the first topic for today is different types of leaves and some of the best practices with regards to handling those leaves. I'll be speaking for the most part about the Ontario Employment Standards Act, referred to as the ESA, which applies to provincially governed companies, private companies in Ontario. So when I say statutory leaves, this means job protected leaves, so that those fall under the Employment Standards Act, and it's where the employer has to grant the leave to the employee and also protect their job or keep their job. And however, the employer is not required in most cases to pay the employee throughout the leave. Then I'm going to discuss a little bit about medical leave under the Human Rights Code before handing things back to Kathryn. Okay, before I get into my specific examples on leaves, the human rights legislation does give 3 specific rights to employees on protected leave that we should really all be aware of. The first is the right to reinstatement. So after the leave has ended, back to their same job or a comparable job if that job no longer exists, and also to the same pay. So if there's an increase that happens across the company during their leave, that they would also be entitled to something like that. The right to be free from penalty and discrimination, so by the employer for requesting a leave or for actually going on leave, and the right to continue to participate in benefit plans while on leave. So for example, health and dental, this meaning that if the employee wants to continue their benefits, they would have to pay their portion of the benefit premium. Great. I wanted to review in detail a few of the leaves that we get most questions about. The first is pregnancy leave. So pregnant mothers can take up to 17 weeks of unpaid pregnancy leave. And at the end of the pregnancy leave, they can commence a 61-week of unpaid parental leave. So that's 78 weeks altogether. Some mothers choose to only take 35 weeks of parental leave for a total of 52 weeks away from work. And there's some reasons for this. One of them is the amount of money that is provided by the Federal Insurance Act, or what we know as EI or employment insurance benefits through Service Canada. And currently the federal government allows for pregnancy benefits for 15 weeks at 55% of the employee's earnings to a maximum of $650 per week. So just note that this 2 weeks is 15 weeks is less than the 17 weeks that are provided under the ESA for the allowed protected leave. And it's just important to note that the leaves that happen in the ESA are going to and can be different than what's supplied in terms of payment by the federal government. So fathers, adoptive parents, and guardians under the ESA can take up to 63 weeks of unpaid parental leave. However, like birth mothers, they can also apply for different levels of EI payments during their parental leave. So this can affect how long the employee chooses to take off from work. So the federal benefit program does allow for 2 options. So the first is a standard benefit of 40 weeks at 55% of salary, up to $650 a week. And of course, they have an extended option of 69 weeks at 33% to a maximum of $390 per week. So parents really do have the option of which one they want to take. Just note that the Insurance Act, or the benefits that are allowable through Service Canada, the employee is only allowed to take, one employee is only allowed to take up to 35 of the 40 weeks of leave. And in the extended version, they're only allowed to take up to 61 of the 69 weeks. So just keep that in mind that your employees have some options when they are ready to go on leave. To qualify for pregnancy and parental leave, employees must be covered by employment standards legislation, which is the majority of listeners today. Also, to qualify, an employee has to be hired for a specific time frame before they can start the leave. Currently, employees have to be employed at least 13 weeks to be eligible for either the pregnancy or parental leave. However, just note that the employee, even if they're off sick or vacation, that can still count as the notice period of that 13 weeks prior to going on leave. In terms of notice, the employee is required to provide at least 2 weeks written notice of their date requested to go on pregnancy or parental leave. And if the employee wants to change that, they are supposed to provide you with an additional 2 weeks of written notice. However, if the employee does give birth prior to or before that 2-week notice is up, obviously that leave will start sooner, and it's just considered to have met that leave notification. And in the case of parental leave, the employee cannot actually start the leave until the baby is born or till the child is in their custody. So although they gave you maybe a 2-week notice of when their leave is expected to start, you might find that it's a day-to-day waiting game until they actually have the child. So I just wanted to go over a few frequently asked questions that we get about pregnancy and parental leave. Firstly, can the partners take leave at the same time? Yes, under the ESA, they can be off at the same time. It's just how they want to work out their employment insurance payments. Like we said, the no more than 35 or 61 weeks under the extended option. When can a mother start their leave? Under the ESA, the birth mother can start their leave anytime 17 weeks before their due date. Do we have to bring the employee back after leave? Many times we get clients who filled the role with someone else over the last year or so who maybe they think is better or is better qualified for the role. But the rule is that the employee does have to come back to the same or comparable role. So if you do want to keep the person you hired and you still want to bring the other person back, and then later on you want to part ways with that person, you want to definitely get your legal team involved to do that properly. What if the employee doesn't want to come back to work? So the employer should expect the employee to return after their leave, whatever date was expected for them to return. If the employee wants to return early, they are supposed to give 4 weeks notice of any return to work before their end date. And same with when they're coming back to work. If they're planning on not returning to your company, they should be giving you 4 weeks notice. Although if an employee doesn't give notice on their return to work date, there's not really a lot of remedy for that under the ESA. So you just hopefully have good communication with the employee and they're honest about when they are going to return to work. Do we need medical documentation? So when an employee requests pregnancy leave, the employee can ask for a certificate from a legally qualified medical practitioner. No medical documentation though is required when the employee returns from their pregnancy or parental leave. What if an employee is sick before the leave? So an employee who cannot perform their duties due to complications with their pregnancy are treated like any other sick employee until their leave begins. So this includes accommodation to undue hardship. So if the employee can do some part of their job, then you can keep them working until their expected leave date. Also, what happens to vacation while the employee is on leave? So your vacation policy should mention that during a leave that time will accrue, but not pay. And so many employees will just tack that unpaid time on the end of their leave. But we always say review your policies and make sure that if you do list in your contracts that vacation is going to be paid 3 weeks regardless of time off or attached to some sort of accrual, that you might owe the employee vacation during like an 18-month leave. So paid vacation. So just keep that in mind as you're reviewing your policies. Next, there are many statutory leaves under the ESA, and I've only listed a few here that tend to cause some confusion. The ESA tends to label things very similarly, so I just wanted to review a few of those. An employee who works sick leave, so under sick leave, the employee who works for your company at least 2 weeks are granted 3 unpaid days for illness, injury, or medical emergency. So if you have a sick plan that provides for more than those 3 unpaid days, you're deemed to have met this qualification. Under the ESA. And previously there was a paid infectious disease emergency leave, which is different from sick leave and was based on COVID. That was 3 paid days. However, that did expire on March 31st of 2023. There's also the family responsibility leave, which is really the same as sick leave, 3 unpaid days, but this is for a family member who might have had an illness, injury, or medical emergency. There's also family medical leave, which is the employee can take up to 28 weeks in a 52-week period to care for a family member who's at risk of dying within the next 26 weeks. And there's no amount of time the employee works for your company, they're allowed to start that leave. And also family caregiver leave, also there's no requirement for how long they have to work to get that leave. And that is 8 weeks per calendar year that the employee can take to look after a family member with a serious medical condition. And then finally, I just want to touch base on critical illness leave, where an employee can take up to 17 weeks to care for an adult who's critically ill and up to 37 weeks for a family member, or sorry, a minor child who is critically ill. And in the case of critical illness, that is a 6-month requirement that they have to have worked with your company to qualify to take those leaves. And just note that employees can qualify for multiple leaves under the same individual situation. So you might have an employee whose mother is at risk of dying within 26 weeks and got the certificate for that, but their life extends past the 28 weeks of medical leave that are family medical leave the employee already took. They can then apply a critical illness leave or family caregiver leave to that same situation. So just keep that in mind, that there are multiple leaves available to employees. Okay, so outside of the statutory leaves that I've just reviewed, you may have an employee who has requested a personal leave of absence for an undisclosed amount of time. Even though it may appear that they shouldn't qualify under ESA, the Human Rights Code does protect employees from discrimination based on illness. So when an employee is suffering from an illness or injury that will extend longer than a few days, usually the employee will come to you and request time off to look after themselves. But occasionally you do have an employee who stays on and is taking multiple sick days, and there's different ways of approaching that. But in both scenarios, your first step will be to review your current policies that you have in place. So for example, what are your paid sick policy? Has the employee exhausted all of those days? Some employees may even choose to use some vacation time. You don't want to force that, but if that's an option your company offers. You also want to review your group benefit plan, and if maybe short-term disability is available to that employee, or STD. So normally STD would kick in if it was hospitalization or an accident right away. And if there wasn't hospitalization or an accident, usually within 8 days or so. And it's just important that you work with the employee to make sure all their forms are filled out properly, so that that whole process of STD runs smoothly. So you are free under medical leaves and documentation. You're free to request a doctor's note to confirm an employee is unable to work. In the case of a shorter illness, a flu or cold, I mean, you could ask for something that's reasonable evidence, like a receipt for Tylenol. However, for those longer sick leaves, you will want to request a doctor's note, and also a medical leave request form, just giving you the specific information that you need, not the diagnosis, just the prognosis of what the employee or what you can expect. You also can let the employee know that if there's a fee for the medical forms, that you're willing to pay for that, to sort of make that clear up front. And also medical documentation is important, really, to understand the length and what accommodations you need to make for that employee. So just try to be empathetic and understanding as well of the employee's disability. So it's easy to think that an employee might be doing it to take advantage of the system, so maybe escaping progressive discipline or potential termination for performance. But just try to rise above and that distrust you feel in that employee, and remain professional and handle things with the employee on a really good and open terms, because keeping that communication open with the employee will ensure that things are done easier. You'll get the information you need from them, and it'll help you decide what your next steps are. And don't force an employee on leave. Obviously, you never want to do something like that, but you can really work with them. If you notice the employee struggling, you can show them all the different options that are available for them if they were interested in doing that. And that way you can, by working patiently with them, you can show that you've acted in good faith and you've tried to do everything you can to support them. Just keep in mind that the employee is not obligated to share any confidential medical information with you. So the employee should submit their completed employee statement and attending physician statement directly to the benefit carrier, and you should just complete the employer statement and send that separately. And often the employees are not able to keep track of the dates and things like that. So it's really helpful if you can make sure that they're keeping on track and making sure all their paperwork is in and handled, so everything goes smoothly. So if you don't have STD, an STD plan with your company, and you would issue what they call a record of employment, or an ROE. And this is generally done through your benefit carrier or through the ROE web and filed electronically with Service Canada. So the employee can then apply for their benefits, which is 55% up their salary up to the maximum 650, the same we saw with pregnancy leave. And the sick benefits formerly lasted 17 weeks, which usually bridged the employee to an LTD plan, a long-term disability plan. But now the government has extended them to 26 weeks, which is great for employees who might not have LTD or need a longer recovery time. We have seen some employers adjust their group plans to not pay LTD until the 26-week period, but a majority of them have sort of at this point just left it at the 17 weeks before LTD would kick in. And it's important to note that LTD benefits are non-taxable to the employee if they are paying their own premium and taxes on that. And also that most LTD coverage stops at age 65. So just make sure employees are aware of that and to check your plan coverage amounts. You'll also want to ensure that your policies speak to when supplemental health and dental group benefits will end. If an employee's on LTD, will they last, 2 years, 10 years, indefinitely while the employee's on leave? It's better to have that listed up front versus at the end of or after they've already started a leave. It makes it much more difficult. You're also entitled to know if the employee has claimed LTD benefits, along with certain basic information like the status of their claim, their ability to perform their own occupation or modified work, and their estimated return to work. So you can definitely work with the insurance carrier to help with that, but we also recommend keeping those lines of communication open with the employee and the employee's doctor just to ensure that you're accommodating appropriately. And also, if your employee is been on LTD for a long time and you're wondering when you can terminate that employee from your plan, definitely reach out to your legal team and make sure that what you're doing is proper and by the books and everyone's on the right page, not just for medical leave, but for any kind of leave an employee might be on. A lot of employers do offer supplemental payments, what we call a top-up to maternity, parental, or medical leaves. And the top-up amount are not considered as earnings and are not deducted from the employee's EI benefit that they're collecting, so long as two conditions are met. The first is when the top-up payment is added to what they're receiving as EI benefit, it doesn't go over what 100% of their normal salary would be. And the second is that the amount of top-up is not used to lower some kind of accumulated benefit, such as vacation or sick time. So employers are not required to register these plans for their supplemental top-up with Service Canada. Unlike some other wage replacements, like when there's a layoff and you're replacing, you do have to register, but for these ones, you don't have to. However, you do have to keep records that you're meeting the two conditions that I've mentioned above. And also, I would say that there is a growing number of our clients and employers, especially in competitive markets, who are offering the top up to employees. They will generally top up to their normal salary, but anywhere between 6 to 15 weeks, we've seen, majority of times on a parental leave or a sick leave, just to give you an idea. Additional requirements may be also added to that top-up plan, so long as they don't break those two conditions I mentioned above. So you might want to say if the employee is going to receive this top-up payment for you, they're required to work for at least 6 months with you after their leave. Just make sure that your policy is good or your agreement is good up front and the employee is signed and aware of it before they head out on leave. The next is just really important to make sure you have a leave request form so you have all the information that you need from the employee. So their reason for request, just not the diagnosis, just the prognosis, how benefit premiums are going to be paid when the employee goes on leave, whether that's e-transfer or checks in advance, however you want to work that. Any special notes on benefit coverage, such as for voluntary leaves, such as how long out of country coverage will last or how long they're allowed to stay on the plan. And of course, language around the coordination, like we talked about just recently, the coordination of top up and how that will work, because the employee does need to provide you with how much money they're receiving under their wage replacement plan so that you can balance the remainder of your top up with what they're receiving. And this is just a sample language for your leave request form. If you are going to offer a top up, just something that talks about how the employee is responsible for letting you know that amount, and that the employee is also responsible for letting Service Canada know on their benefit application that they're the ones, how much money they're receiving as a top up. So I know that was a lot of information about leaves. It's probably overwhelming, but definitely reach out to us or Devry with any questions you have. And now I'm going to turn things over to Kathryn to discuss termination.
Thank you, Stacy. So terminations are an unfortunate reality of the employment relationship, and I'm going to cover some best practices to help you prepare and successfully get through them. So first, at the very start of the employment relationship, we always recommend that you work with your employment lawyer to ensure that your employment agreements have clear termination language. Many of our clients don't want to talk about termination at the beginning of the employment relationship because they think it has negative connotations, but we don't want you to worry about that. It's super important, and most employees will expect and want to know what your company's termination clause is, and they'll be happy to see that their potential new employer has an excellent, well-crafted employment agreement because it speaks well of the company. We recommend that your termination clause limits with specific language the amount of termination pay the employee will be entitled to, while being 100% certain that you're meeting all employment standards and legal regulations. You can be creative and add your own termination clause in regards to a fixed entitlement or a formula based on years of service, as long as it goes over and above the minimum Employment Standards Act regulations. And of course, work with your employment lawyer, and they'll help to ensure that everything you need to include in your termination clause is there. A key item that I want to mention that is often left out of an employment agreement termination clause is that you'll also want to consider and state what happens to short-term and long-term disability coverage and when those will end when an employee terminates. Employers run the risk of being liable for LTD coverage during notice of termination periods where it's not stipulated in the employment contract when it ends. And this will be a problem if your insurance carrier has already terminated the employee coverage under the group benefit plan. So a word of caution is to make sure you've confirmed with your benefit insurance carrier how long all of your employee benefit coverage, including STD and LTD, will last once an employee is terminated, and adjust your offer of employment accordingly to set appropriate employee expectations. My next few slides will cover employer responsibilities related to terminations. So first, to cover a commonly asked question, can an employer ask an employee to quit? So for example, an employee nearing what the employer believes to be an appropriate retirement age, or what if there's an employee who's not fitting in with the team and whose skill set is lacking and the employee seems to know it? The black and white answer is no, and that when it's the employer's choice to sever the employment relationship, the employer must follow the Employment Standards Act and provide appropriate notice, and in some cases, additional severance payments. However, before we get into those details, from an HR perspective, we do guide our clients to assess each situation for its own unique merits. If it's an employee who you think is open to separating from the company, but they just don't know when or how to end it, most often because of fear of financial hardship, then we do encourage a careful, well thought out conversation with the employee. We've held many conversations with employees where we open the meeting by saying we want to have an open and honest conversation about how the employee is doing and how the company can help them reach their goals. We listen carefully to the employee speak, and if they express an interest in leaving, and here you must, again, listen carefully and not pressure the employee or lead the employee, but if they express an interest in leaving, it can lead to you being able to ask if the employee is open to working together on an exit strategy, which will give them a runway before separation to support their financial concerns. And more often than not, we find that employees in these situations are relieved and receptive to working with the employer on an exit strategy because it achieves three important things. One, it gives some control back to the employee. Two, it addresses their financial fears because if they quit, there's no severance payments and they cannot collect employment insurance benefits. And three, it allows them to leave with dignity in front of their colleagues, since communication to the wider company is going to be a retirement or a resignation. Of course, if the employee does agree to this route, we do work with an employment lawyer, with Marty, on a separation agreement outlining the agreed upon terms, such as working notice, or if there was a mix of working notice and pay of lieu of notice, etc. So employee terminations do not have to be adversarial, but only if they are well planned and done in good faith. And Marty will give an example later on that will highlight what happens if you don't work in good faith. So next, let's turn our attention to once the termination decision has been made, what does the employer need to provide to employees? An employer must provide a written termination letter and a record of employment known as the ROE, which Stacy mentioned earlier. The ROE generally has to be provided within 5 days of the termination. And with the ROE, ROE, you must provide the reason for issuing the ROE, and Service Canada uses this information to determine if and when the employee will qualify for employment insurance or EI benefits. So I'm going to go through some of the most popular ROE reason codes and provide some advice on them. So I'll start with quit. Quit is very self-explanatory. The employee has voluntarily resigned. So that's an easy one to choose. Code A is one of the most commonly used codes. Use this code when there is a shortage of work or layoff because, for example, the employee's contract is ending or the season is over or you're eliminating their position. We often find that employers overuse Code A because they're timid to show that the employee has been dismissed, because they don't want to risk offending the employee, or because they want the employee to receive employment insurance benefits. However, be very cautious here. You open your company up to liability if a former employee that you laid off using Code A hears that you've hired someone in the same role, even if it was many months later. The employee can take action against you, such as suing for wrongful dismissal, because you misrepresented why they were terminated. So please only use Code A if the reasons I listed are the reason and it's a legitimate reason for the termination. Another common code is Code M. So this is the code you use when you as the employer initiate the separation and the employee is leaving the workplace because you've dismissed them. So don't shy away from using Code M. If the termination meets the definition of dismissal, then use it. Often Service Canada will call to find out more specific reasons for the termination if the employee has applied for EI, and they'll look at the reason. So if it was a wrong skill set for the company or within the probation period, the employee may very well apply for EI benefits. That'll be up to the Service Canada officer reviewing the file. Next, be very cautious about using Code A, which is the other code. This will trigger an automatic call from Service Canada, and they'll probe and tap you, slap you across the knuckles if you've used this code incorrectly, and you should have used Code A or Code M. Code A is really just for things like you've changed payroll providers or your company has a different name, like it's a bureaucratic reason for a shift in employment. You can put comments for Code A to explain it. Make sure you're using it correctly. For the other codes that I've mentioned and all the other codes on the ROE, we recommend strongly do not add comments, because just use the proper code and don't add comments, because that's going to slow down the EI application process for the employee. They get kicked into another bucket where Service Canada has to call and your employee is going to be waiting for their benefits. So a key takeaway from this slide is that if your role is that it's your role as the employer to make sure you select the correct reason for issuing the ROE and to not falsify the reason on the ROE. So per Service Canada, failure to issue the ROE or complete it fraudulently can result in a fine of up to $2,000 or 6 months in jail, which, truth be told, I have never heard of any of this happening, but I felt it important to mention to you. So the next slide is just an example of a termination letter, just to show you how we highly recommend you put as much detail in the termination letter as possible, because the employee will have a lot of questions and it's the right thing to do to make sure they have the information. Next, so aside from the physical documents you must provide when terminating an employee, perhaps the single most important action you'll take when planning a termination includes the calculation you will do to determine the notice period for the termination. You can choose to provide working notice or pay in lieu of notice. Working notice means that you can tell an employee on a Monday that effective immediately they have X amount of weeks or months left to work before their employment terminates. This is done when there are no security concerns and you have a strong relationship and reason for providing the working notice, and it'll work well for the company. Versus the more common pay in lieu of notice, which means that you can tell an employee that their job is terminated effective immediately, but the employee will get a lump sum payment in lieu instead of actually working through the notice period. Or you can also do a salary continuance, but their work has stopped with the company. Generally, the minimum employment standard is that the employee gets approximately 1 week of notice for each year of service to a maximum of 8 weeks of notice of termination. Also, on top of this, Ontario and for federal employees, for employees of a certain seniority, a lump sum severance payment based on length of service must also be paid on top of the ESA notice pay or period. In Ontario, for this to be true, you have to employ more than 50 employees and have a payroll of over 2.5 million in Ontario. And importantly, you also have to consider common law when thinking about notice of termination. So distinct from minimum employment standards, but extremely important when you're determining the appropriate notice to provide to a terminated employee is common law. Common law is based on legal precedent, and it increases the notice periods that should be given to employees. It increases the notice period that should be given to the employees, and tied to the common law notice are the individual characteristics of the particular termination that you're dealing with, which you tap into because it affects how much common law notice to provide. So, for example, if you're terminating a 62-year-old product specialist who's worked for your company for 30 years, the notice of termination would be much more than 1 week per year of service, since the employee would most likely have difficult finding a comparable job due to their age and because their career has been focused on your specialized product. This is an example where working with your employment lawyer is key to ensuring you present the employee with a fair termination package to reduce liability for your company and to give your employee the cushion they need to either secure a new job or bridge them to retirement if this is a factor. So we always recommend working with your employment lawyer on common law considerations and notice packages. So also remember that when terminating an employee, all outstanding vacation pay must be paid to the employee and benefits maintained throughout the notice period. This means the ESA statutory notice period, and it could be through the common law period if your contracts do not stipulate otherwise. And those are the things you're going to want to make sure you understand and have clear up front before the termination. Lastly, you can't change any conditions of employment during the notice of termination period. So for example, you can't decide that just because the person is leaving anyway to reduce their hours or responsibilities. And next, although very rare, common law entitlements do not apply if the employee is terminated for cause. So for cause or just cause terminations occurs when the employment relationship is severed because the employee has committed, for example, fraud, theft, or willful misconduct. Be cautious, for cause terminations are very difficult to prove, and you must ensure you've documented and have concrete reasons for it to hold up if challenged. So for example, performance problems would be very difficult to justify as a for cause termination, even with documentation. It's always advisable to have your employment lawyer confirm you're taking the appropriate actions before terminating an employee for cause. So turning now to the termination meeting preparation, you've done all your notice calculations, you know what you're doing. You're going to want to prepare also for the termination meeting. Be sure to select a time and place that allows for privacy. I personally do not believe in a rule that there's a specific or better day of the week to do a termination. To me, the best practice is to make your termination meeting considerations around the employee's privacy and dignity to allow the employee to depart without there being a scene. This can be an early morning meeting before everyone is in the office, or at the end of the day when most people have left, or depending on your work environment and culture, you can do it if they're working from home via video call. Also, when preparing, finalize who will participate in the termination meeting. Keep it small, so it's normally just the manager and one other representative, usually from HR. You don't want it to be intimidating for the employee. Also consider when and how the rest of the employee's team will be notified, and work with HR or the manager on a wider company communication and when that communication is going to be sent. Sometimes direct team members are notified in a separate meeting at the same time as the employees being terminated, or you can let the team know and others know after the termination meeting. It depends on your culture. Another consideration is if the employee is allowed to walk around the office to say goodbye to their colleagues. This is rare, and normally HR asks the employee to leave their company equipment and leave immediately following the meeting. And of course, if they're upset, you give them time to sit and absorb the news before they get up and go. If they do have belongings to collect, a manager or HR person should accompany them for security reasons to pick up their stuff. And I'll touch on belongings in a second on the next slide. So the correct way to proceed really depends on your company's precedent and company culture, but don't leave the logistics unclear. Have a plan and execute it thoughtfully and carefully. Also, to prepare for the termination meeting, consider when you'll make IT aware of the termination, so they know when to shut down the employee's system's access. For example, is their email and access going to be shut down during the termination meeting or at another time? During the meeting is the most common approach for pay in lieu of notice terminations. Also, prepare and let IT know in advance what the employee's out of office emails should say, it should be clear who the forwarding emails are going to, and that the employee is no longer with the company. And also think about things like, how is the employee going to receive their pay stub if they're online with your company, and their T4 at year end? How are they going to get that? And finally, have a plan for equipment return. Will you agree upon a future time to meet up for the person to return all their items, or will you mail a prepaid box to their home address where they can put everything in it and return it to you? Clarity around these logistics help lay the groundwork for a smooth termination. And finally, when you've made it to the actual termination meeting, keep it brief. And when I say brief, I mean, I'm talking 10 minutes, 15 at the most. Sometimes they're 5 minutes. Do not plan for a long period of time. Keep it brief and be sure to set your personal feelings about the termination aside and be direct and to the point and professional while maintaining empathy. So for example, don't make small talk at the beginning of the meeting, but instead pre-plan who will speak first, the manager or the HR rep, and start, for example, right away with saying the reason for today's meeting is an unfortunate one. Today is your last day with the company, something along those lines. And then do a high-level summary of the termination package with the employee. A best practice is to mention that the termination letter is going to be provided, but do not provide it at the beginning or during the meeting. Provide it at the end of the meeting, or else the employee is just going to stare at it and not absorb and not want to leave. Giving the letter to the employee at the end of the meeting gives you a way to wrap up the meeting and kind of usher them along home to read the letter. If it's online, you email the letter to their personal email address after the meeting's over. And another best practice is to acknowledge the employee's emotions. So saying things like, we understand this is difficult news. Don't lay blame. Don't say, I didn't make the decision. It wasn't my decision. Never do that. Support your employer, but you can be empathetic during the meeting. And if the person asks for reasons for the termination, which almost always they do, keep it brief and don't go into detail, unless of course if it's a for cause termination, you give the clear breaches of company contract and policy. But for all other terminations, be succinct. For example, the position has been eliminated if it's a true layoff, or if you're providing notice, you're not required to give a reason, but if they probe you, a best practice is to keep it general, such as it's not a good fit, and the employer will probably ask for more details. We find that they do. Be prepared for this, but do not provide any breakdown of the reasons. Just repeat, it's not a good fit, but it is a without cause termination with notice, and the details are in the termination letter we are providing you, and that the decision is final. Sometimes you might have to repeat that sentence over and over, and that's okay. Don't get bullied into giving more information than you need to. Do not give details. Also, remember to remind the employee that they should not share details with others beyond that they're no longer with the company, and review with them what to do if a colleague or client reaches out to them to ask details for who they should contact. Make sure that employee has referral names and contact names that they can give to those clients and employees for who they can follow up with. And of course, remind the employee of confidentiality agreements signed upon hire. by far the easiest way to end a termination meeting, like I mentioned, is to let them know that you're now providing the termination letter for them to review when they are home and alone and can absorb it, and provide them a clear contact to reach out to with any questions, and remind them if it's a pay in lieu of notice meeting that there's no further work for them to do. That also can be a point of confusion for an employee. Be very clear about that. So next, my final comments on termination include ensuring that in your termination letter, you make it clear to the employee what happens to their group health and dental benefits and RRSP contributions upon their termination. For example, when's the last day they can make health and dental claims to their benefit plan? And ensure they're aware if they can convert their life insurance into a private plan, and provide the contact details of how to do this in the termination letter. And in the termination letter, include who they contact to transfer their group RRSP to another plan, and ensure they're aware of the fees to do so. So again, just in summary, include as many details as you can in the termination level, and do that high level review at the termination meeting. And being prepared and doing this will give both you and the employee some stress relief, since terminations are never easy. So it's good to be prepared. And that's the end of the termination presentation. So thank you for listening. And now we'll take a break and we'll all gather back here at 11 a.m.
Okay, welcome back from the break, everyone. We are going to move along now with our 2023 case law update. And before I go on, thanks to Kathryn and Stacy for those very informative presentations, and for all your questions. I think we've managed to get through just about all of them so far. So the case law update, it's only April here, but there have been a number of new employment law cases, and we're going to go through 5 of them in this part of the presentation. So the first case that we are going to look at is called Croak and Viewpoint Systems Limited. This is a 2023 case of the Superior Court of Justice. So here we have an employee who was employed as a systems technician by the employer. And the employee was regularly required to interact with customers in their home to provide the installation of telecommunication services. The employer, so Viewpoint, had signed supply agreements with Bell Canada, which stated that Viewpoint was required to comply with Bell's policies. Now, Bell introduces a mandatory COVID-19 vaccination policy on or about September 8th of 2021. And then so Viewpoint, to ensure compliance with Bell's policy, pretty much has its hands tied and decides to implement its own vaccination policy, which required employees to provide proof of vaccination. So this was the first 2 doses. Now, under Bell's policy, employees who did, under Viewpoint's policy, rather, employees who did not provide proof of vaccination would be prohibited from performing work with certain customers. And importantly, Bell provided more than 99% of Viewpoint's business. And finally, there was no mention of any consequences for failure to comply with Viewpoint's policy. So the employee refuses to provide proof of vaccination, and as a result, the employer terminates his position and alleges frustration of contract. So we'll see more about the specifics of frustration later, but simply put, frustration occurs when there's some sort of intervening event that was not contemplated by the 2 contracting parties, which now substantially alters the contract and was not foreseen by either party. So the plaintiff says, well, the employer never warned employees what the consequences would be, and therefore it wasn't really legal or appropriate to terminate the employee for frustration. And the employer argues that, well, if you're not providing proof of vaccination, you can't perform any work anymore. So that's the basis for the frustration. And the court agrees with the employer. So the court says, yes, this contract was frustrated, and the employee is not going to be entitled to notice of termination. So again, because the employee was not in compliance with the policy, he was now unable to perform any work because Bell now had this vaccination requirement in place. So this slide addresses the frustration test. And as we saw earlier, frustration happens when there's some sort of intervening event which makes the contract radically different from what was intended by the parties. And the court agrees that the employment relationship was altered by the implementation of Bell's mandatory vaccination policy, and that was not contemplated by either party. And the court also found that the change in the employment relationship was due to Bell's actions, so again, a third party, and that the employer did have an obligation to comply, so the employer didn't really have a choice in that regard. So here, this is actually the first Canadian court decision to determine that an employee's refusal to comply with the COVID-19 vaccination policy can amount to frustration. But again, significantly, this decision does involve facts in which it was a third party that first imposed the vaccination policy, and we don't have any case law yet where it was in fact the employer and not a third party who first introduced the policy. So our next case here is called Celestini and Shop Logics, also 2023, this time decided by the Court of Appeal, the highest court in Ontario. So the employee signs an employment agreement in 2005 to perform the role of chief technology officer, and some of the duties involved transferring product and corporate knowledge. The employee is terminated still in his role of CTO until 2017, when he's fired without cause. The employee sues for wrongful dismissal and argues that the termination provisions contained in the 2005 agreement should be found unenforceable, not based on the way that they were drafted, but rather because there had been material changes in his employment duties, despite the fact that the employee's job title had not changed. So the motion judge, the first judge who heard the case, did favor the employee in his ruling, and noted how he had found that the employee's duties had changed. So there were changes with respect to the bonus structure, and there were clear changes with respect to the employee's workload and responsibilities. And given these changes, the judge found that the employee's new responsibilities were substantial and far exceeded any predictable or incremental changes to the employee's role that would have been reasonably expected when he started the role back in 2005. And the employer appeals to the Court of Appeal. The Court of Appeal still sides with the employee. Now, at the Court of Appeal level, the court elaborated a little bit on what we call the changed substratum doctrine. So in other words, in this case, if an employee's termination clause may become unenforceable if the duties and employees of that employee have changed over time. And significantly, the court found that we're not just looking at what the employee's job title is. Really what they are looking at is any changes to the duties and responsibilities themselves. Now, the good news for employers here is that by way of an employment contract, the changed substratum doctrine can be ousted. So if the contract expressly states that the other provisions of it will continue to apply, even if the employee's position, responsibilities, salary, or benefits change, then the employer has avoided this problem altogether. But here, the court found for the employee and ultimately awarded an 18-month common law reasonable notice period. Now, I'll just say here that while it's preferable to address this issue from the start, if you're an employer and you already have a contract in place, but there is no mention of a clause which says that the contract will remain in place regardless of any changes to the employee's duties, then you have to be careful, because if the employee is going to get a raise and is going to start engaging in different duties with substantially different responsibilities, if you want that termination provision to still be enforceable, or there's other provisions that you still want to be upheld, then it's probably time, I think, to have the employee sign a new contract, which is going to reflect that. The next case is called Park and Costco Wholesale Canada. So here we have a 20-year employee who was terminated without notice after he twice deleted a website that he created for the employer's use. And for those who might be interested, this was a Google cloud-based website that was being used for internal file sharing. Now, the employee acknowledged that he had deleted the website. So really the issue here was whether or not his actions ought to result in a termination for cause. So in other words, does the punishment fit the crime? The employer argued that this deletion was willful, intentional, and together with the plaintiff's other subordinate behavior, the employee had sent some pretty insubordinate emails saying, well, the employee was upset that the employer hadn't gotten back to him about, I guess, how much he liked this website. So the employee sent emails saying, well, you never got back to me, and it's not my job to babysit you, and things like that, which the employer did not like, and neither did the court ultimately. So the court looks at the McKinley test with respect to dishonesty and misconduct. So in other words, again, is the termination for cause a proportionate response to the employee's misconduct? Okay, it's going to be a factual inquiry at the end of the day. And here the court finds that, yes, the employee's conduct was sufficient to establish just cause. So first, the employee had deliberately deleted company property in contravention of the employment agreement. The employee didn't even tell the employer that that's what he had done. He had sent his boss misleading and inflammatory emails, and the employee had simply breached the level of trust that the employer had placed in him, because this was an employee who had security access and was able to modify the employer's website and systems. So the court finds that, yes, termination for cause was an appropriate and proportionate response. So the court then gets into what willful misconduct is, and we heard Kathryn, I think, talk a little bit about this already. Willful misconduct is a higher standard under the Employment Standards Act that an employer must meet in order to deprive an employee of their minimum ESA entitlements. And on this slide, I just want to look at the third bullet point here. This is a quote from the court's decision. The court says this was not conduct that was merely careless, thoughtless, or inadvertent. Mr. Park's conduct was not trivial, and it was not condoned by Costco. Mr. Park was colloquially being bad on purpose. So if you're looking for a way to explain to someone what, willful misconduct is, under the ESA, well, there you have it. If it's the employee is being bad on purpose, there you have it. Willful misconduct under the Employment Standards. So takeaway here, I mean, you've probably heard me say on many occasions that, proving just cause and willful misconduct is very difficult, and that still remains true. But at the end of the day, it's not impossible. And here's an example of a case where the employer managed to win. They're all going to be fact-based inquiries. But if you're dealing with employees who are in a higher level of responsibility and there's multiple acts of misconduct, I'm not going to say that you're going to win for sure as an employer, but I will say that your chances of winning will be significantly improved. let's look at our fourth case. This one is called Sachetto and Canada. So this is an employment insurance case. The applicant applies for EI after getting fired. He was fired because he didn't comply with his employer's vaccinate or test policy, which was enacted under Directive 6, for those of you who might be interested. So the Canada Employment Insurance Commission says, well, sorry, not complying with this vaccinate or test policy does amount to misconduct, and therefore you're not entitled to employment insurance benefits. The employee then appeals to the Social Security Tribunal, not successful there, then to the Social Security Tribunal's appeal decision, still unsuccessful, and now brings this case for judicial review at the federal court. So the applicant argued that the decision of the Social Security Tribunal didn't actually get into the legality of requiring employees to undergo medical procedures where the efficacy and safety hadn't been established. Okay, the court had to analyze, what exactly is considered misconduct for the purpose of EI eligibility. So this is going to be conduct, it's misconduct, actions must be performed consciously, deliberately, or intentionally, and they don't actually have to have malicious intent in order for an act or omission to be characterized as misconduct. So the federal court also rules against the employee, finds no basis to interfere with the many decisions of the adjudicative bodies below it. And the court simply says, look, you were terminated because you knowingly failed to follow the employer's vaccination policy. So there's the misconduct. The court goes on and says it's not really our job, to get into an analysis of whether or not the COVID vaccines are safe. And I mean, in this policy, this was a vaccinate or test policy. If the employee had simply agreed to perform regular rapid testing or antigen testing at a regular interval, this case probably wouldn't have gone as far as it did, but the employee refused to do that. So this is an example of the federal court reaffirming the test for misconduct for the purpose of EI eligibility, and shows us that an employee's failure to comply with a COVID-19 vaccination policy can amount to misconduct for this purpose. And then last but not least, we're going to get through a case here called Telliger and Aurora Hotel Group. This is a case where the employer was found liable for moral damages based on the manner of termination. So here we had a plaintiff who was working as the general manager of a resort when he was terminated without cause after the employer decided to retain an outside management company to manage the resort. And in addition to seeking damages for wrongful dismissal, the employee sought moral damages for the employer's breach of the duty of good faith in relation to the termination. Now, in this case, the employee recorded the termination meeting, and as we'll see, this was relied upon by the court in its decision to award moral damages. So moral damages are the same as aggravated damages, okay, and there's a very specific legal test for awarding them that courts have to consider. Basically, it comes down to whether or not the employer has treated the employee in good faith, whether the employer has engaged in any conduct that was untruthful, misleading, or unduly insensitive, and whether it was within the reasonable contemplation of the employer that conduct could cause mental distress to the employee. And we're talking here about mental distress beyond what we call the normal hurt feelings that accompany a dismissal. So here, not only did the court award 7 months of pay in lieu of notice, but the employee was also entitled to $15,000 in moral damages. And specifically, the court found that number one, the employer failed to provide written notice of the termination to the employee, despite the employee's numerous requests. and also in contravention of section 54 of the Employment and Standards Act, which requires exactly that terminations be communicated in writing. As well, the employer failed to pay the employee's ESA entitlements, termination pay, severance pay, within 7 days of the termination, or the employee's last day of work. Third, the employer made promises which weren't kept. So, for example, the employer had promised to reimburse the employee for business expenses. That wasn't done. And also to provide 8 weeks of severance pay, or actually the employer actually promised to provide slightly more than that. And then that never happened. And then finally, so in Kathryn's presentation, she addressed, employee resignations and, whether employers can or, should talk about that. In this case, the employer did actually suggest that the employee could resign. Didn't really force the employee to resign, but suggested it. The court listened to the recording of the termination meeting, heard that, and said, well, maybe the employer did that to try and avoid paying ESA entitlements and common law, because an employee who resigns is not entitled to that. But the court wasn't really sure exactly why the employer was doing that. But the court said, well, we can't really rule this out, so I don't like this. So the court ultimately found that, the employer had encouraged or suggested that the employee resign from his employment, and actually relied upon that in support of the moral damages award. Final point here was the court also addressed an argument from the employee that the employer threatened to call the police if the employee were to come back on the premises, and the employee didn't really think that was very nice or necessary. But the court said, look, that doesn't result in moral damages. The employer is entitled to control access to its premises, and there's nothing wrong with saying, please don't come back, and if you do, we may have to call the police. Okay, so quick takeaways here. I mean, an example of the case where the court was quite happy to consider an employee's recording of a termination meeting. So just be careful at termination meetings. Okay, you never know if an employee is recording the meeting, and they are allowed to do that, even if they don't get specific consent from you as the employer. And to avoid moral damages, best advice I can give you is to comply with your statutory obligations, keep promises made to employees, and really just comply with statutory requirements, and just be reasonable and be fair at the end of the day. So that concludes my presentation. We are now going to move right into the Q&A period. We have about 10 minutes, or just under, give or take, to address any questions that might be there. Okay, there's another question here. Yes, we are going to be providing the presentation slides. Not to worry, just contact any of the presenters or go to our firm's website. Not to worry, though, we will get you the slides. Okay, so I actually don't see any other questions that have come in right now. It looks like Kathryn and Stacy did a great job of answering the few other questions that I noticed during the presentation. So we seem to be good. I will make my quick wrap-up comments now. If you think of any final questions, feel free. I see one already, so we'll come to that. Actually, let's just see what that one is here. Okay. Yes, you are welcome. The question here says, thanks to everyone for answering my questions. Okay, well, thanks everyone. CPD codes, will be sent here after the seminar. Oh, there's another question here. What are some examples of ROE code K? Well, some examples that I think are given on the Service Canada website are things like if the payroll provider changes, or if the employer is going from, say, a bi-weekly pay cycle to a monthly pay cycle, or something like that. Kathryn, you're nodding. Are there any other
Yep.
ones you can think of?
Those are the main ones. And when you're in the ROE web, it shows you, but those are the main ones. It's not performance problems, or I kind of like the employee, but it just didn't work out. It's nothing. You do not use the code code other for that, please.
All right. Okay, so let's wrap things up. So thanks everyone once again for coming. I think we have gotten through what we can here with the questions here. Oh, okay, here is something that you will all like, and I'm going to send this right now. So Fawzon says that the slides are available on our website. Okay, so it looks like there is a complete deck here. So what I'm going to try and do is I'm going to post the link here to the slides for everyone as an answer to the questions. So there was a question that was submitted by participant named E. Jones. Thanks to everyone for answering my questions, and the link is right there. So there is the link to everyone who needs the slides. So anyone, thanks again for coming. If you have more questions, feel free to contact any of the presenters. We typically put on these seminars about once every quarter, so once every 3 months or so. So the next seminar that we will be putting on here at Devry Smith Frank is likely to be in June. So stay tuned for that next date. So once again, I'm glad you were able to join us. Don't forget to claim your CPD hours for HR professionals and for lawyers, and have a great day. Thanks, everyone.